of the development for modern duty of care has happened within the last 100 years, it is still very much an ongoing debate. Today, however, a three-stage test is used to determine whether or not there is a duty of care, derived from Caparo Industries and Dickman. They are, number one, whether or not it is foreseeable, the defendant's behavior was reasonably foreseeable. Two, whether or not there is sufficient proximity between the parties for a duty of care to be imposed. And three, whether or not it is fair, just, and reasonable in all the circumstances to impose a duty. This concern with fairness and justice is the foundation of the tort of negligence, and it has been argued that its relevance comes into question when it is used to receive compensation, but fairness and justice are not achieved. Discussing whether or not the tort of negligence is still relevant today only becomes possible when negligence is defined. So, what is negligence? In law, negligence is described as number one, a duty of care owed to the defendant, to the claimant by the defendant. Two, a breach of that duty. And three, non-remote damage caused by a breach. Only if these three elements are proven will a claimant be able to successfully receive compensation for his damages in court. The tort of negligence has developed through the years. The question of when and to whom one owes a duty of care to another is among the most contested principles in tort. In the early stages, privity of contract was necessary in order for a duty of care to exist. However, it was the case of Heaven and Pender where it was first established that under certain circumstances, a duty of care may exist even if no contract exists between the parties. However, it was the landmark case of Donahue and Stevenson where the tort of negligence was truly developed into its modern form and the three elements of negligence was established. Following this case, a more expansive approach to duty of care was taken up in Annes and Merton London Borough Council, where policy considerations were taken into account. However, there was a retreat from this approach in Governors of the Peabody Donation Fund and Sir Lindsay Parkinson Co. and Limited, where it was asked whether or not it was just and fair to impose a duty of care was a more appropriate test than mere policy considerations. Given most of the development for modern duty of care has happened within the last 100 years, it is very much still an ongoing debate. Today, however, a three-stage test is generally used in order to determine whether or not a duty of care exists, derived from Caparo Industries and Dickman, which is whether or not the consequences of the defendant's actions are reasonably foreseeable, whether or not there is sufficient proximity between the parties for a duty to impose, and whether it is fair, just, and reasonable in all the circumstances to impose a duty of care. Hey guys, a new case just came up. A police car just crashed into a civilian's vehicle while chasing a murder suspect. The civilian now wants to claim for damages, thinking that the police is responsible. What do you think?
Thank you, Kristen. There are actually two ways of looking at it, whether or not the negligence claims could be brought up against the police.
Yeah, if we were to look back at the decision of the House of Lords in the Hill and Chief Constable of West Yorkshire in 1998, in which the claimant's 20-year-old daughter got attacked by a convicted murderer who had committed a number of the same crime in the same area. The claimant filed an action against the police, the defendant, for being negligent and breaching his duty of care to the general public. However, the appeal was dismissed because it was held that police officers do not owe a duty of care to the general public at large to apprehend unknown criminals nor the individual members of the public. Therefore, I would say that in many events, as a matter of public policy, the police were immune from allegations, negligence arising from their investigation and suppression of crime.
And what do you think such a decision was made?
Well, according to Lord Templeman, this action is misconceived and will bring more harm than good. A policeman is a servant of the public and is liable to be dismissed for any incompetence. A police force serves the public, and any public representatives who are elected by the public must ensure that the public gets the police force they deserve. It may be that the West Yorkshire police force are in some respects better and in some respects worse than what the public deserves. An action for damages for alleged acts of negligence by individual police officers in 1980 cannot determine whether or not the police of West Yorkshire can be improved in 1988. I would dismiss the appeal. Not only that, the police would be inhibited by the exercise of their professional judgment. Large amount of money and police time would be diverted to defending civil cases instead of actually investigating the actual crime.
A few moments later.
But there's also another way to disagree with the case. If you look in a more recent case of Robinson and Chief Constable of West Yorkshire Police, it was Mrs. Robinson, a 76-year-old lady. She was walking down the street of Huddersfield and she was knocked over by a group of men. Two of them were policemen trying to catch a suspected drug dealer. Mrs. Robinson fell and she suffered injuries from this. Okay, so from that case, it was held at the Supreme Court that there was no general rule that the police were not under any duty of care when discharging its functions and investigating a crime. That they generally owed a duty of care in accordance with the ordinary principles of law of negligence, and unless a statute or a common law provides otherwise. In the case, Lord Mance commented that we should now recognize the direct physical interface between the police and the public in the course of an arrest, placing an innocent bystander or a passerby at risk as falling within a new established area of general police liability and a positive negligent conduct which foreseeably and directly inflicts physical injuries to the public. On the facts, Lord Reed found that the result to have been reasonably foreseeable as a result of the actions of the police by attempting an arrest on a busy street. It was foreseeable that any one of the public could be caught up in the struggle. Additionally, Lord Reed thought that there would be sufficient causation, and with the attempted escape by the suspect did not break the chain of causation. Therefore, the Chief Constable of West Yorkshire Police was found liable and the case was remitted back to the lower courts for assessment of damages to Mrs. Robinson.
And what would this mean for future claims?
The judgment is likely to have a dramatic effect on the ability of potential claimants to bring legal actions against the police. While the courts are unlikely to allow the floodgates of litigation to be opened, the judgment in Robinson has certainly removed on what has been an immediate bar to clients commencing civil claims against the police forces in England and Wales. Not only that, the case of Hill can no longer be considered as authority for the proposition that the police can enjoy immunity in respect to anything they do in the course of investigating and preventing crime. The police may therefore be under a duty of care to protect individuals from the danger of injury which they themselves have created. The injury caused to Mrs. Robinson, for example, was caused by the officer's breach of duty, and she was injured as a result of being exposed to the danger that they had a duty to protect her from. Therefore, it can be argued that the thought of negligence is still relevant today within the police force as illustrated in the Robinson case.
Well, it looks like we have to go through the details of our clients and see how we'll tackle it.
Well, yes, we should. Hey, doctor. There's someone from the legal board wanting to seek your advice.
Okay, have a seat.
Hi, doctor, so have you heard about the recent claims against our hospital? So this is the summary of the claims against us.
I'm telling you, these litigation claims against doctors are a waste of time. The problem lies with the tort or fault-based system. Inherently, it is adversarial in nature. The task of the courts and you lawyers and you judges is to find justice between the available evidence and the law. The problem comes when the courts itself are unreliable, when there are things such as judicial impartiality, when there are such things as disadvantages of tactical maneuvering, stuff like partisanship, and just the general unreliability on the witnesses and the people called to court. Such problems with the court system makes it really difficult to achieve real justice, as there's an inequality in legal representation between both claimant and defendant.
That's really general though. What do you mean?
You see, for medical claims especially, there's the added factor of unreliability of the expert witnesses. For a medical negligence litigation claim, there is a need to obtain expert medical witness views to discern whether a particular act or omission constitutes a breach of duty. The problem primarily comes from us doctors not being so willing to share what happens in the medical room, as there are multiple economical and psychological reasons why we do not want to share what happens in our line of duty. Another reason is that doctors feel a greater duty towards their fellow professional colleagues or their fellow professional doctors than they would to a member of the public who may have suffered from a negligent action. This is because doctors do not like to testify in court against fellow doctors and risk professional isolationism in the office or in the hospital. Another compelling reason is the economical reason. Most doctors share the same medical insurance companies. As such, if a fellow doctor were to testify against another doctor, it would harm the financial well-being of the medical insurance company. Thus, the medical insurance company has the power to refuse or to cancel the professional liability insurance of any and all doctors.
But that's the problem between doctors, not the law.
I mean, you have to think about it. The effects of a medical negligence claim against a doctor is highly detrimental towards both his person and his reputation. The mere publicity of such a claim is gonna damage his reputation because it insinuates faulty practices and judgment of character. His career as a doctor is gonna be derailed by a lot, and not only that, he's gonna start doubting himself and start avoiding patients he could have gave treatment to because he wants to avoid the risk of a negligence claim. This not only affects doctors, but it really negatively affects the relationship between the patient and the doctor, as patients who have illnesses but would require a risky operation but is savable might be ignored by the doctors, as the doctors are afraid of a negligence claim being brought against them. As such, the tort system or the litigation claim, as it is adversarial in nature, it makes the doctors and the patients enemies rather than allies, which is detrimental to the medical community as a whole.
You bring up some good points, but there are also benefits demonstrating how the law has worked so far. Consistency of judgment, also known as the doctrine of binding judicial precedent, allows the rule of law to be upheld because it requires states to foster coherent legal rules as well as application of those rules. This doctrine allows the purpose of law to be served, which is to serve justice as well as equality. Without it, there could easily be an abuse of power or inconspicuous unfairness, which also may trigger the need for a new interpretation of the law, which will lead to the overruling of the precedent itself.
Oh, what do you mean by that specifically?
If we were to refer back to the Chelda Anak Lelaki Manicum and another and Kerajaan Malaysia case back in 1997, in this case, the plaintiff's 10-year-old daughter was diagnosed to suffer from appendicitis, when in reality she actually suffered from pancreatitis. The treatment carried out by the doctors of the Penang General Hospital thus was for appendicitis, instead of pancreatitis. This led her to be unstable and later causing her death. The plaintiff brought an action against the doctors, claiming that they had been negligent in diagnosing the disease. The federal courts of Malaysia had used the Bolam test in order to determine whether or not the doctor can be held liable. In this case, the plaintiff must be able to show that the doctors had a duty of care that they had owed to the patient, and also that the omission of the doctors had caused the breach of duty, in which the claim was successful as they were able to prove these points.
Well, in my opinion, mediation is a better alternative to medical negligence claims especially. This is because mediation is a process where two parties voluntarily enter into discussions and resolve their disputes only and only if both parties consent to the judgment. This would solve the problems of litigation claims, such as a lengthy period of time to conclude a litigation claim, as both parties are willingly exchanging information presently. The other problem would be the attack on doctors' character and judgment and reputation, and this solves the problem as litigation claims are public while mediation is a private matter. And finally, just in terms of principle, litigation in tort law is more or less not focused on healing, whereas mediation is focused on the fundamental goals of medicine, which is open exchange of information, human relationships, and healing in general. As such, I feel, in summary, that negligence is still relevant today. However, for medical negligence, the approach we take towards those claims are irrelevant and outdated, and we should update ourselves to use mediation in such claims.
I do agree with you that the current system is flawed. Lord Templeman once said that the duty of the medical practitioner is to provide the patient with sufficient information in order for them to come with a balanced judgment. In Malaysia, the Bolam test, like applied in the Chelias case, while long applied, has never had strong roots. The Malaysian courts tend to use the Rogers test, as we can see in the Fu Fiona case, which came before the federal court in 2007. This particular aspect of medical negligence has more to do with the doctor giving advice to the patient in order for them to give their consent on the proposed medical treatment.
So, the reasonable man has had a long history in the history of law and practically inseparable from the idea of negligence at this point. So we should go back to when it was first introduced, which was in the case of Vaughan v. Menlove in 1837. Ever since then, it has survived numerous and extensive reconceptualization. The first of which came in the case of Blythe v. Birmingham Waterworks in 1856, as Alderson redefined the idea of the reasonable man as a single standard rather than multiple standards. And following that, in the landmark case of Donahue and Stevenson, it expanded the scope of the reasonable man beyond just specific and bailment activities such as the carriage of goods or passengers or transactions involving dangerous goods. The centrality of the reasonable man towards the idea of negligence as a whole is made quite evident from the words of Alderson in the aforementioned case of Blythe, as he stated, the reasonable man is something akin to, and this is his quote, the omission to do something which a reasonable man, guided upon those considerations which ordinarily regulate the conduct of human affairs, would do, or doing something which a prudent and reasonable person would not do. The problem with the reasonable man's test is especially evident if we look at it from the context of applying the test towards a section of society who are unfairly discriminated against in the eyes of the law, which is the medically insane persons. Such persons are born with certain brain defects or mental personality issues which makes them incapable of fully understanding the actions and consequences of what they have brought. And as such, the reasonable man is an unfair standard to compare them against, as they are simply not normal. This problem is further elaborated if we take into account the aim of the law of torts and why the law of torts exists. Two aims I will specifically look at is corrective justice and tortious liability as a deterrent. Now, corrective justice is meant to ensure that the wrongdoers make amends for what they have done wrong. For example, if a jaywalker was walking and a car had to swerve past him, the car owner can claim for negligence by the jaywalker as he is doing something negligent in the eyes of a reasonable person. However, if an insane person was put into that position, an insane person might not know that it is not the right time to cross the street. As such, the idea of corrective justice is that the insane person has to pay back the car owner. This is especially problematic if you take into account that corrective justice and financial solvency are closely related. A reasonable man would have, say, insurance to insure him against any such accidents, and he can use it to claim money to pay back his debts. However, insane people, due to society's perception of their, say, employment status, have more difficulty in obtaining insurance. As such, the idea of corrective justice to make amends for whatever wrongs they have done fails to apply here, as the insane person is simply financially incapable of correcting whatever wrong he has done. Now, the second one is tortious liability as a deterrent, which is basically tortious liability is used to make people who have done wrong to contemplate on their consequences and actions. However, an insane person would not be in his right state of mind or not of sound mind to properly contemplate what he had done wrong, which is what the deterrence theory is based on. So, to sum up, the idea of corrective justice for the wrong party to make amends to the person they have wronged, as well as tortious liability as a deterrent, both fail when trying to apply it to an insane person. As a matter of fact, in general, the idea of the reasonable man's test fails to account for a medically insane person, as medically insane people cannot be expected to hold up to a standard that they are incapable to achieve through no fault of their own. In conclusion, the idea of negligence in a case of a medical insane person is quite outdated and irrelevant and should be looked at and updated for modern times. Today we'll be talking about the tort of negligence. Could you please share your opinion on whether the tort of negligence is still relevant today?
Well, one aspect that we can look at today is in the overlap of torts. So sometimes we use the tort of negligence to kind of fill in the gaps for other areas of tort, such as defamation or private nuisance. So we have sometimes even the tort of negligence can be looked at in contract law or constitutional law or other areas of law. So right now we'll look at the overlap of torts. So we have, for example, the tort of defamation and the tort of negligence. We'll take the case of Spring and Guardian Assurance Public Limited Company in the year 1994. So what happened there was the plaintiff who was a company sales representative. He was dismissed from his job by the first employer, which is the first defendant. So this defendant was asked to write a letter of reference to his prospective employer. So what this first defendant, his old employer, did was he actually wrote a rather negative reference about this plaintiff, which was actually untrue, but this employer didn't actually know that. So as a result of that, the prospective employer refused to appoint the plaintiff. So what this plaintiff wanted to do was he wanted to sue him for defamation, but he couldn't sue the defendant for defamation because in defamation you actually have to prove malice, and they couldn't prove any malice in this case. So what he did was he resorted to the tort of negligence. So he said that the defendant was actually negligent and he gave a negligent misstatement and that he owed a duty of care to give a proper statement about the plaintiff. So that actually was accepted by the courts and the defendant was held liable. So here you can kind of see where the torts of negligence and defamation have been, it's been used to fill in the gaps because they couldn't prove malice for defamation. So one of the judges of the case, Lord Wolf, he actually said that this overlap of torts actually helps to benefit a person where this person would have failed if he used the tort of defamation, but instead he used the tort of negligence and therefore he was able to get what was due to him, what was his right. So in that way it's very positive.
Alright, thank you for your expert opinion. However, there are many today who would say that the tort of negligence is irrelevant. What is your take on it?
Well, okay, let's look at the same aspect here, right? The overlap of torts. So in Daniel Moore's journal titled The Boundaries of Negligence, Volume 4, he said that this fill in the blanks concept kind of results in a vagueness of the law. So yes, it's good that, sometimes you can sidestep the problems of defamation, because in defamation you have to prove malice and that's quite complicated and quite difficult to do. So what we can do and what will benefit a person, especially when it comes to this person's right, is that you use the tort of negligence. But the problem that Daniel Moore actually posed was, how far will this tort of negligence evolve? Are there any boundaries? Will it keep evolving? Are there no set of rules? Can you just use it in any way you deem fit? So this is a problem. And he also suggested that instead of sidestepping the requirements of defamation by using negligence, you could actually just make some amendments to defamation and its requirements of proving malice especially.
Even though road accidents are well established in the tort of negligence, we still have to ask two questions. The first being, does it really fulfill the primary objective of tort law, which is for the victim to receive fair and just compensation for his losses? And two, does it really deter drivers from driving negligently? In road accidents, tort judgments are mostly paid off by liability insurers rather than the tortfeasors themselves. This effectively shelters the tortfeasor from the economic consequences that are supposed to act as the primary deterrent. In negligence, justice in the form of negligence comes from shifting the loss from the innocent party to the party that committed the wrong. This begs the question of whether or not the role of negligence in its capacity to fulfill community notions of justice is really relevant in terms of road accidents, considering the loss is shifted not to the tortfeasor but to the insurance companies. So why not shift the loss from the insurance companies back to the tortfeasor? Well, the case Nettleship and Weston illustrates why insurance companies may still be necessary. In this case, the defendant, who was a learner driver, went out for a lesson with her friend, the claimant. Before going out with the defendant, the claimant checked to see if the defendant's insurance policy covered passengers. While driving, the defendant crashed into a lamppost and the claimant was injured. Speaking on this case, Lord Justice Denning stated that although morally the learner driver was not at fault, legally she was at fault because she was insured and the risk should fall on her. It seems obvious that a learner driver would not be able to meet the standards of a reasonably competent driver. However, without the presence of insurance companies, the defendant would have to pay for the claimant's injuries out of her own pocket, which does not seem fair. But injuries still occurred, and the claimants should still be compensated. To do otherwise would seem like an even bigger breach of justice than letting the tortfeasor escape the economic consequences by letting insurance companies pay for the damages. Therefore, insurance companies protect drivers with lower skill levels and ensures that tort that victims always get compensated for their losses. Furthermore, the volume of road accidents make it impossible for courts to look at them at a case-by-case basis, making negligence seem like the most feasible option.
A more recent application of the Donahue and Stevenson case in Malaysia is the Abdul Malik bin Idros and Tan Jihan case, which was brought before the court in 2013. In this case, the appellant was in a car chase with a suspect, and they were against the traffic flow. This had led the suspect to hit the claimant. So the claimant had brought a claim against the defendant, stating that claiming that the injury was foreseeable and that the police officer had breached his duty of care. However, the court held that there was no proximity, thus the claim against the defendant had failed.
And this shows that, yes, up to a certain extent, the tort of negligence is actually still applicable in today's society, especially in Malaysia. However, there are several contemporary issues that have proved that maybe to a certain extent, the tort of negligence is actually inadequate in today's modern society. Therefore, to draw up a conclusion, perhaps in order to cope with the recent changes of time, we could resort to other methods of resolving disputes, especially in the medical field, such as going to alternative dispute resolutions and several other modifications to the tort of negligence could be done just to make negligence still relevant in today's society. So yes, we would say that only to a certain extent today the tort of negligence still stands.